Now that you've completed the second book, I want to congratulate you on having no more readings for this semester. I want to also ask you to consider what the American Bill of Rights tells you about the revolutionaries. But in doing so, I recommend thinking about it as historians. Think not what it means to us today, but what it meant to them when they wrote it. A quick glance at the text of the 10 Amendments in the Bill of Rights shows that they are not a list of the rights that Americans enjoy. They are instead a list of prohibitions on the federal government. They tell us what the federal government is not permitted to do. It does not list what is owed American citizens. You see this when you read the words, "Congress shall pass no law concerning this or that." And you see it when you study the history. Despite the First Amendment, Americans lived with an established religion in most states of the United States for many years after the ratification of the Bill of Rights. State governments established an official religion, and citizens of those states had to pay taxes to support that particular church. So it's inaccurate to say that the Bill of Rights declares that Americans have a right to be free of established religion. Instead, the First Amendment simply declares that the federal government is prohibited from establishing an official religion. So if someone tells you that the rights in the Bill of Rights are not absolute, you have my permission, and Madison's permission, to dismiss that claim out of hand. The prohibitions in the Bill of Rights are absolute, as evidenced by the English language and early American history. However, that's not to say that the framers of the Bill of Rights were radicals or anarchists. They understood that governments could, and even should, limit various freedoms. Punish you for falsely yelling fire in a crowded theater, prohibit child pornography, limit your free exercise of some wacky and violent religions, confiscate your guns, etc. But they left it to local governments to enact these limitations. They prohibited absolutely and in clear and absolute terms the federal government from enacting any such limitations. By the same token, the Articles of Confederation and the Federal Constitution, both, are not philosophical statements on how to govern people. The framers of the first and second U.S. Constitutions understood that these documents explained only how the central government should operate. These were constitutions regulating only the central government, not the other levels of government in the United States. So the founders understood that most of the governing is done and should be done beneath this national level of government by various local institutions. Most governing was done by families and civic institutions people belong to, churches, charitable associations, voluntary militias and associations, etc. Municipal governments governed less, county and state governments governed less than that, and the national government governed less than that. So when you see how little these framers expected the national government to govern, you shouldn't conclude that they were anarchists. You shouldn't conclude that these founders of the Republic denied all governments the right to regulate guns and speech and religion and people's various pursuits of happiness. They understood that societies regulate and restrict these things all the time by necessity. All they said in these two constitutions was that this regulation shall not be done at all by the central government. This should allow different communities to do these things differently. Some towns would have official churches, or gun control, or habeas corpus, or speech codes. Some would not. Some states would, while others would not. Indeed, like I said with regard to state religions, we see that this was so in the late 18th and 19th centuries.